Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week relates to the use of force under international law and how that has changed in the post-9/11 era. So let's get started. The simple answer to the question is yes, with a few exceptions that are often exploited and which we will discuss momentarily. The structure of the interstate system is based on the presumed equality of sovereign nations. As in any system based on the equality of its members, the implication is that every state should be free from coercion, and similarly, its territory and sovereignty should be inviolable. Indeed, this is the general principle that underlies the modern international system. No state, in principle, is superior to another state, and no state can compel another state to act in a particular manner through forceful coercion. In the 20th century, conflicts between the major powers became increasingly costly and destructive, as new means and methods of warfare, such as automatic weapons and airplanes to drop bombs, were introduced. This led to the development of international treaties and agreements designed to limit the resort to war. For example, the international response to World War I was the creation of the League of Nations, a group of states dedicated to maintaining peace between the major powers. The League, however, would collapse in the face of World War II. In addition to the League, there were other pacts in the interwar period that also sought to regulate conflict. The Kellogg-Briand Pact, also known as the General Treaty for the Renunciation of War, was completed outside of the League of Nations framework in 1928. Under that pact, war is outlawed. The contracting parties agreed to condemn the recourses to war for the solution of international controversies and renounce it as an instrument of national policy in their relation with one another. The main legal document for our purposes, however, in dealing with the legality of using force is the UN Charter, adopted in the wake of World War II and legally binding on all of its members. When the 5 permanent members of the United Nations Security Council affixed their signature to the UN Charter, U.S. President Truman addressed the conference, noting that the Charter was, quote, victory against war itself, close quote.
Let us not fail to grasp this supreme chance to establish a worldwide rule of reason, to create an enduring peace under the guidance of God.
The potential use of force is regulated by Article 2.4. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. Now, the word force, instead of, for example, war, was chosen to ensure that all military actions were included, and that the rules would not be limited to situations where there was an official declaration of war, which is quite rare. Importantly, although it was debated, it did not include instances of pure economic force. Under the Charter's prohibition, force is only prohibited if it is used against the, quote, territorial integrity or political independence of another state. And what does that mean? Well, first, force is still prohibited even if it's not for the purpose of the acquisition of territory. It is also prohibited to permanently threaten territory or the political independence of a state. A temporary occupation, a quick raid, all that is considered illegal. In general, any coercive incursion of armed troops into a foreign state absent consent for any reason will violate the territorial integrity or political independence of that state and is therefore considered an illegal use of force under international law. International law allows the use of force in 3, arguably 4, situations. The first, consent. You can send your armed forces to help another state if asked. The second is self-defense. You can use your armed forces to defend yourself from attack. The third is the collective use of force. You can use your armed forces at the request of the UN Security Council. And the fourth, more controversial, is the humanitarian interventions. You might be able to use your armed forces to prevent heinous attacks against civilian populations, although this use has certain limitations that we will address in coming lectures. One of the primary and perhaps the most evoked and even the most abused exceptions to the international legal prohibition on the use of force is that of self-defense. Now, before talking about the Charter, we do need to look to some general international legal principles regarding self-defense that derive from customary international law. First, under customary international law, the use of force in self-defense must be both necessary and proportional. Necessary means that you have exhausted all peaceful methods of conflict resolution, and proportional means that the purpose of the use of the defensive force must relate to the force that is to be countered. The UN Charter essentially adopted the general rules of self-defense into its charter. Article 51 provides, quote, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council." Now, taking the UN definition, we can see that a state can use force in the event it suffers an armed attack, including potentially by non-state actors. Now, a state doesn't have to wait until it is actually attacked. International law allows for the taking of preemptive action. The law, however, limits such actions to when an attack is imminent. As you will see in the readings this week, the question of what is an imminent attack plays a large role in how states address the issue of self-defense in the post-9/11 era. The principal purpose of the United Nations is to, quote, "maintain international peace and security, and to that end to take effective collective measures for the prevention and removal of threats to the peace," close quote. The responsibility for doing so was vested with the UN Security Council. Importantly, the UN Security Council was given the unique authority to enforce the peace, both through peaceful means like sanctions and diplomatic coercion, as well as, if necessary, by collective enforcement action. Under Article 39, the Security Council has the sole authority to determine when there is a threat to world security, and to make recommendations as to what is to be done. Importantly, though, the UN was not provided with its own army. It must rely on contributions from members, and historically such efforts have been led by groups like NATO. We should note here, however, that because of the makeup of the Council, the use of collective force is very rare. It was used in 1950 to repel the North's invasion of South Korea, but only because Russia was boycotting the panel. It was used again in 1990 to repel the aggression of Saddam Hussein's Iraq against Kuwait, and it was used arguably to create a no-fly zone over Libya that eventually led to the ouster of Muammar Gaddafi. But that's it. 3 uses in 70 years. Now, although the UN doesn't have an official army, it has used its members' forces to raise what are called peacekeeping forces. These forces wear the famous blue hat of the UN. What's the purpose? Well, there are 2 models of peacekeeping, a traditional and a modern one. Traditional peacekeeping involved lightly armed soldiers under the UN flag that are only allowed to use force in self-defense from attack or armed interference with their mandate. Their purpose is to essentially stand between the 2 warring sides and create a buffer zone. This type of peacekeeping is usually present with the consent of the territorial state and all the parties to the conflict. It is a way of diffusing potentially volatile situations. The modern model usually involves the implementation of a comprehensive peace settlement in the aftermath of conflict, where peacekeepers are responsible for maintaining order, administering elections, and creating new institutions. They're also responsible for the delivery of humanitarian aid, as compared to the traditional model where they act merely as a buffer between the warring parties. It's more of a nation-building role. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.